Welcome to this property law update from Landmark Chambers. Today we're going to be talking about the recent case of New Look CVA, Lazari Properties versus New Look Retailers that was decided earlier this week. I'm joined by specialist property barrister David Nicholls to talk us through the decision and its implications. David, can you tell us what this case is all about?
Well, good afternoon. I think the context of this case is really important. First of all, it's in the context of the pandemic, and that has caused some very serious issues for commercial landlords. Many retailers have had to shut up shop, they've had no income, they haven't therefore been able to pay the rent, and there's been genuine hardship for many businesses. So you've got that context, and of course you've also got the context of the restrictions introduced by the Coronavirus Act, so landlords can't forfeit leases where tenants are not able to pay the rent. But at the same time, you've got the courts saying, well, obligations to pay rent must be upheld and enforced, and there was a recent decision of Master Dagnall in the High Court confirming that. So landlords have got their claims in debt for the unpaid rent, but they've got limited means to take that further. And what tenants are doing, and this is what happened in the New Look case, is they're entering into company voluntary arrangements as a means of restructuring, compromising those debts in order to encourage the business to move forward after the arrangement has come to an end. And these CVAs are unpopular with landlords, who often feel they have to bear an unfair share of the pain. They feel they're forced to keep retail tenants at substantially lower rents. And the New Look case was really the latest in a succession of challenges to CVAs by landlords.
Thank you, that's useful. And what's the background to this particular CVA?
Well, New Look is a well-known high street chain. They have over 400 shops up and down the country, employing around 10,000 people. And because of the problems caused by the pandemic, the rental income that it was able to pay reduced, the retail income from the business reduced, the rent it was paying to the landlords effectively had to stop. And in August last year, New Look entered into a CVA. And part of the terms of that was that landlords had to accept a turnover rent, which is a rent that's based on a proportion of the turnover, and the rent arrears were written off. So it had pretty serious consequences for landlords, but 80% of the creditors voted in favour, and that's more than the threshold. So the CVA was approved, but the landlords took the challenge to court.
And on what basis did they make their challenge?
Well, the judge described the challenge as a root and branch attack on the use of CVAs, and it was really quite a formidable challenge in that sense. It went to the very heart of what a CVA is. There was a jurisdictional challenge. The allegation was that this was not a true CVA at all. There was a challenge on the basis of unfair prejudice, and there was a challenge on the basis of material irregularities in the process of approving the CVA. And at the heart of the landlord's case were really two contentions. The first was that the CVA cannot be used to effect two or more deals, two or more arrangements on substantively different terms between different groups of creditors. The landlord was saying, really, what we've got here is more than one arrangement under the overall package of a CVA, and therefore this is not a genuine CVA. And the second main contention was that it was inherently unfairly prejudicial to compromise claims where the majority of those voting in favour of the compromise were not in fact being compromised themselves. They weren't affected by that compromise. So in relation to jurisdiction, the argument was that the CVA involved separate arrangements on different terms. It wasn't a true CVA. In relation to material irregularity, the landlord said that there was insufficient information disclosed about the restructuring overall, and that vitiated the decision-making process. And in relation to unfair prejudice, the landlords complained that the votes of creditors not affected by the CVA was binding on those who were adversely affected, and this was unfairly prejudicial. It was unfairly prejudicial that different creditors were treated differently, and also it was unfair because of the various lease modifications.
And what did the court decide?
Well, the court rejected these challenges The court took the view that differential treatments between creditors was permitted. And I think of great significance is that the court identified 4 factors to be considered when assessing whether there had been unfairness. The court did say that in relation to the potential unfair prejudice in the lease modifications, these were really addressed or balanced by the grant of a right to the landlords to terminate the leases. In effect, the position was, well, landlords, you either stick with the CVA and you accept the rum deal you've been given, or you've got this option of getting out and finding somebody else to take over the property. If that counterbalancing right wasn't there, then the court did recognise potentially it would be unfair, but it was there in this case, and therefore the court rejected those challenges.
And it's been a busy week, hasn't it, in relation to these types of cases? And already there's been another relevant case, the Virgin Active case.
Well, that's right. And as I said at the beginning, the New Look case was really the latest in a long line of challenges, which have all been unsuccessful, challenges by landlords to CVAs. And indeed, there was another one that was decided yesterday, the Virgin Active case. And in that case, the CVA involved a complete write-off of unpaid rent and the use of the cross-class clampdown, which was something new introduced by the Corporate and Insolvency Governance Act last year. And the landlords were the second largest group of creditors in the Virgin Active case, but the secured creditors were far larger in number, and they supported the CVA. And the landlords' challenge was rejected in that case as well. The court ruled that the landlords would be no worse off in the CVA than in administration. And so it was therefore better that the CVA should be allowed to continue so that there was some chance of the company being saved afterwards.
How do you see landlords' reactions to these particular cases and developments during the week?
Well, there's been some really fierce opposition to these cases. There's been considerable disappointment for property owners. A lot of hopes have been dashed. There's been a lot of upset. And there's real concern that landlords are sharing a disproportionate burden in relation to CVAs. And indeed, there have been concerns about the consequences for the economy overall. Is there, in fact, a shift of wealth going from property owners and landlords to shareholders in a company who end up with an unfair benefit, landlords would say.
Thank you. That's been a really useful summary. Thanks, everybody, for watching.